It sounds simple. Find a field, set up a sound system, get some people together and have a rave. But once the gathering reaches the legal thresholds, the police gain powers that go far beyond simply asking you to turn the music down. In this video, we're going to look at what the UK law actually calls a rave, when police can order people to leave, when equipment can be seized, and why noise laws can cause problems even when your gathering falls outside the formal definition of a rave. Living on the road, Waterways or off-grid in the UK, Dickie Dread. And we're on part 47 of the video series in chapter 6, Parties, Gatherings, Raves and Festivals. And today we will cover regulations on raves. A rave is typically understood as an unlicensed or unauthorised gathering, often taking place in an outdoor or non-traditional venue such as a warehouse, field or abandoned building, where people gather to dance to electronic music, techno, drum and bass, house and the rest. In practice, what matters is not the label but the scale, sound and setting. These events are usually characterised by the following: loud music amplified through large sound systems, large crowds, often hundreds or more, unlicensed or informal organisation with no formal permission or licensing, late night hours running overnight or into the early mornings, countercultural atmosphere, often outside mainstream regulation. From a legal standpoint, the key law is the Criminal Justice and Public Order Act 1994. Under Section 63, a rave is defined as a gathering on land in the open air of 100 or more people at which music is played during the night, where the music is wholly or predominantly characterised by the emission of a succession of repetitive beats, and the noise is likely to cause serious distress to inhabitants of the locality. I love the repetitive beats bit. Well, I love and hate it. That definition matters because it triggers police powers. If these conditions are met, police can direct people to leave the site, stop people travelling to the event, remove vehicles and equipment, and seize sound systems and associated kit. The offence is not simply attending, but failing to comply with a police direction. If you refuse to leave or ignore instructions, you can face fines and up to 3 months imprisonment. And yes, in practice, seizure of equipment does not always look gentle. These gatherings can also occur on waterways, particularly when multiple boats come together. In these cases, the same public orders powers apply, alongside any action taken by navigation authorities. If the event takes place on land you own or occupy, you may be treated as facilitating it, even if you did not formally organise it. Providing access, power, structures or simply allowing it to happen can bring you into the scope. It is also worth noting that the threshold is about scale and impact. Smaller gatherings can still be shut down under other powers, trespass, breach of the peace or noise nuisance, even if they do not meet the formal rave definition. Stricter COVID-era fines introduced in 2020, including £10,000 penalties for organisers, I remember that, and I know people who've been charged it, are no longer in force, but they showed how quickly enforcement can escalate when the state decides to prioritise control. Emergency powers can return, so the legal landscape is not fixed. As ever, the pattern is the same. It's not just what you do, but how visible it becomes. The moment it crosses from contained gathering to something that affects others, the law starts to bite. Noise regulations. Excuse me. Noise management in the UK is primarily governed by the Environmental Protection Act 1990. This legislation empowers local councils to investigate complaints about noise that could be considered a statutory nuisance. If noise from premises, vehicles, boats, equipment or machinery in the street is deemed excessive and detrimental to health or quality of life, councils can issue noise abatement notices, requiring the cessation or reduction of the noise. Non-compliance with such notices can result in fines, equipment seizure, which should often require a warrant, and further legal action. Additionally, the Environmental Noise England Regulation 2006, which transposed the Environmental Noise Directive into domestic law, require regular noise mapping and action planning for major sources of environmental noise, such as roads, railways and airports. While these regulations focus on broader environmental noise, they underscore the importance of managing noise to protect public health and well-being. Local authorities also play a crucial role in noise regulation through the planning system. When new developments are proposed, potential noise impacts are considered to ensure they do not adversely affect existing communities. This process is supposed to help prevent future noise nuisances by assessing and mitigating potential issues during the planning stages. In summary, the UK has established comprehensive legal frameworks to regulate raves and control noise levels, balancing the facilitation of social events with the protection of public order and the community well-being. Like it or lump it, just setting up and going for it can be dangerous and has gained many a poor soul a clump with a baton and a seizure or destruction of their equipment. So calling something a private party, gathering or rave does not determine how the law treats it. Scale, location, noise, licensing and the effect on other people are what matter. If you're trying to live differently, this isn't just about throwing a party. It's about understanding where a gathering crosses the line into something that gives councils or the police powers to intervene before discovering it the hard way. And sometimes the hard way involves watching your sound system disappear into the back of a police van. In the next video, we'll look at the regulations on festivals, where organising something larger and more public brings another layer of licensing, planning, safety requirements into play.